Several European Union member states have territories which, for historical, geographical, or political reasons, enjoy special status within or outside the European Union. These statuses have a wide range of derogation from EU policies. Most of the territories which are outside the EU nonetheless have a special relationship with the EU. Map: Outermost regions. The outermost regions are territories forming part of a member state, situated a significant distance from mainland Europe, which are part of the EU. According to the Treaty on the Functioning of the European Union, both primary and secondary European Union law applies automatically to these territories, with possible derogations to take account of their structural, social and economic situation, which is compounded by the remoteness, insularity, small size, difficult topography and climate, economic dependence on a few products, the permanence and combination of which severely restrain the development. 7 outermost regions were recognized at the signing of the Maastricht Treaty in 1992. The Treaty of Lisbon included 2 additional territories, in 2007, both of which seceded from one of the original outermost regions. St. Barthélemy changed its status from OMR to October with effect from 1 January 2012, while Mayotte joined as a new French OMR with effect from 1 January 2014. As of April 2014, a total of 9 territories were registered to have OMR status. Autonomous regions of Portugal, Azores and Madeira are 2 groups of Portuguese islands in the Atlantic. Azores and Madeira are integral parts of the Portuguese Republic, but both have the special status as autonomous regions, with a degree of self-governance. While derogations from the application of EU law could apply, none do. The VAT is lower than the rest of Portugal, but they are not outside the European Union value-added tax area. Canary Islands. The Canary Islands are a Spanish archipelago off the African coast which forms one of the Spanish autonomous communities, thus having the status of being part of the Kingdom of Spain. They are outside the European Union value-added tax area. The Canary Islands are the most populated and economically strongest territory of all the outermost regions in the European Union. The Outermost Regions Office for Support and Information is located in these islands, in the city of Las Palmas de Gran Canaria. French Overseas Regions. French Guiana, Guadeloupe, Martinique, Mayotte, and Air-Cute Union are 5 French overseas regions which under French law are, for the most part, treated as integral parts of the Republic. The euro is legal tender and they're part of the European Union Customs Union. However, they are outside the Schengen area and the VAT area. Mayotte is the newest of the 5 overseas departments, having changed from an overseas collectivity with October status on the 31st of March 2011. It became an outermost region and thus part of the EU on the 1st of January 2014. Collectivity of St. Martin. On the 22nd of February 2007, St. Martin was broken away from the French Overseas Department of Guadeloupe to be formed into a new overseas collectivity. As a consequence, its EU status was unclear for a time, while a report issued by the French Parliament suggested that the island remained within the EU as an outermost region. European Commission documents listed it as being outside the European Community. The legal status of the island was clarified on the coming into force of the Lisbon Treaty, which lists it as an outermost region. Overseas countries and territories. The overseas countries and territories are dependent territories that have a special relationship with one of the member states of the EU, and have been explicitly invited by the EU Treaty to join the EU-October Association. They were listed in Annex 2 ACC. to Article 198 of the Treaty on the Functioning of the European Union, which aside from inviting them to join OCTA, also provided them the opportunity to opt into EU provisions on the freedom of movement for workers and freedom of establishment. Yet the freedom of establishment is limited by Article 203 TFEU and the respective Council decision on OCTs. Its Article 51 prescribes only that the Union shall accord to natural and legal persons of the OCTs a treatment no less favourable than the most favourable treatment applicable to like natural and legal persons of any third country with whom the Union concludes or has concluded an economic integration agreement. Again, this can be, according to Article 51, limited. The obligations provided for in paragraph 1 of this article shall not apply to treatment granted under measures providing for recognition of qualifications, licenses or prudential measures in accordance with Article 7 of the General Agreement on Trade in Services of the GATT's Annex on Financial Services. The OCTs are not subject to the EU's common external customs tariffs but may claim customs on goods imported from the EU on a non-discriminatory basis. They are not part of the EU and the EU acquis does not apply to them, though those joining OCTA are required to respect the detailed rules and procedures outlined by this association agreement. OCTA members are entitled to ask for EU financial support. When the Rome Treaty was signed in March 1957, a total of 15 OCTs existed: French West Africa, French Equatorial Africa, St. Pierre and Miquelon, Comoros Archipelago, French Madagascar, French Somaliland, New Caledonia, French Polynesia, French Southern and Antarctic lands, French Togoland, French Cameroons, Belgian Congo, Rwanda, Urundi, Trust Territory of Somalia, Netherlands, New Guinea. The list was since then revised multiple times, and comprised, as noted by the Lisbon Treaty, 25 OCTs in 2007. One of the French territories subsequently switched status from OMR to October, while another French territory switched from October to OMR. As of July 2014, there are still 25 OCTs, of which 22 have joined OCTA. The 3 OCTs which are not part of OCTA do not have a permanent population. British Overseas Territories, 12 overseas territories of the United Kingdom, and the sovereign base areas of Akrotiri and Dhekelia on Cyprus, namely, Anguilla, Bermuda, British Antarctic Territory, British Indian Ocean Territory, British Virgin Islands, Cayman Islands, Falkland Islands, Montserrat, Pitcairn Islands, St. Helena, Ascension and Tristan da Cunha, South Georgia and the South Sandwich Islands, Turks and Caicos Islands. Bermuda did not, despite having October status as defined by the Rome Treaty, join the EU October Association together with the other overseas territories in November 2001, but instead only joined OCTA on the 2nd of July 2014. As of July 2014, it is only the 3 remote areas without any permanent population that are not members of OCTA. All citizens of the British Overseas Territories, except those residing at Britain's sovereign bases in Cyprus, were granted full British citizenship by the British Overseas Territories Act 2002, and are consequently citizens of the European Union. French Overseas Territories. A total of 6 French overseas territories currently have October status within EU. The French Southern and Antarctic lands is a French overseas territory but has no permanent population. It has sui generis status within France. St. Pierre and Miquelon, St. Barthélemy, French Polynesia, and Wallis and Futuna are overseas collectivities of France, while New Caledonia is a sui generis collectivity. St. Barthélemy and St. Pierre and Miquelon use the euro, while New Caledonia, French Polynesia and Wallis and Futuna use the CFP franc, a currency which is tied to the euro and guaranteed by France. Natives of the collectivities are European citizens owing to the French citizenship, and elections to the European Parliament are held in the collectivities. On the 22nd of February 2007, St. Barthélemy and St. Martin were separated from the French Overseas Department of Guadeloupe to form new overseas collectivities. As a consequence, their EU status was unclear for a time, while a report issued by the French Parliament suggested that the islands remained within the EU as outermost regions. European Commission documents listed them as being outside the European Community. The legal status of the islands was clarified on the coming into force of the Lisbon Treaty, which listed them as outermost regions. However, St. Barthélemy ceased being an outermost region and left the EU to become an October. On the 1st of January 2012, the change was made to facilitate trade with countries outside the EU, notably the United States, and was made possible by a provision of the Lisbon Treaty which allows the European Council to change the EU status of a Danish, Dutch, or French territory on the initiative of the member state concerned. Dutch overseas territories, 6 territories of the Netherlands, all of which are Caribbean islands, have October status. The inhabitants of the islands are EU citizens owing to the Dutch citizenship, but few of them had, until recently, the right to vote in elections to the European Parliament. Their exclusion from the franchise was ruled to be contrary to EU law by the European Court of Justice, as Dutch citizens resident outside the EU, other than those resident in the 6 islands, did have the right to vote. Aruba, Curaçao, and St. Martin are classified as countries under Dutch law and have considerable internal autonomy. In June 2008, the Dutch government published a report on the effect on the islands were they to join the EU as outermost regions. It concluded that it would be for the islands themselves to weigh up the advantages and disadvantages of becoming part of the EU as outermost regions, and that nothing would be done absent the islands specifically requesting it. Bonaire, Sint Eustatius, and Saba are special municipalities of the Netherlands proper. In June 2008, the Dutch government published a report on the effect on the islands were they to join the EU as outermost regions, their current October status, and the prospect of advancing the status to become part of the EU as new OMRs, has been scheduled to be reviewed by the Dutch Parliament in 2015, as part of the planned review of the Dutch law concerning the quality of the recently implemented new public administration bodies. The islands inherited their October status from the Netherlands Antilles, which was dissolved in 2010. The Netherlands Antilles were initially, specifically excluded from all association with the EEC by reason of a protocol attached to the Treaty of Rome, allowing the Netherlands to ratify on behalf of the Netherlands in Europe and Netherlands New Guinea only, which it subsequently did. Following the entry into force of the Convention on the Association of the Netherlands Antilles with the European Economic Community on 1 October 1964, however, the Netherlands Antilles became OCTs. Greenland joined the then European Community in 1973 along with Denmark, but voted to leave the EC in 1982 and left in 1985, to become an October. Greenlanders are, nonetheless, European Union citizens owing to the Danish citizenship. The EU-Greenland relationship is a comprehensive partnership, which is complementary to the October Association arrangements under Council Decision 2013/755 EU, based specifically on Council Decision 2014/137 of 14 March 2014, and the Fisheries Partnership Agreement of 30 July 2006.